If you've been charged with a DUI in Florida, you effectively have issues in two different places. You have an administrative law issue and you have a criminal law issue. The purpose of this video is just going to cover the administrative law issue. So in Florida, if you're arrested for a DUI and you provide an unlawful breath alcohol level, which is 0.08 in Florida, it will trigger a license suspension of 6 months. If you have a previous DUI conviction and you provide a breath sample, it will suspend your license for 12 months. If you have refused to provide a breath sample, or you provided a breath sample but refused a urine sample on a first offense, it will trigger a 12-month driver's license suspension. And if you have a prior refusal, it will trigger an 18-month driver's license suspension. There are effectively three things that you can do, or three options that you have about your driver's license. Do note that this decision needs to be made within 10 days from date of arrest. As silly as it may sound, your DUI citation, so the little rectangular piece of paper that you got from the police or when you were released from the jail, is a valid driver's license for a period of 10 days and 10 days only. During that 10-day period, you will have to decide between three options on what to do about your administrative driver's license suspension. Option number one is to do nothing. If you do nothing during that 10-day period, or if you have waited more than 10 days to do something, it will trigger that 6 to 12 or 18-month driver's license suspension, depending on how many DUIs you have in your past, whether you refused, or whether you provided a breath alcohol level that was over the legal limit of 0.08. You will have to wait at least 30 days if you provided a breath sample over the legal limit, or 90 days if you refused to provide a breath sample or urine sample if lawfully requested, to request a hardship license, which is an employment purposes or business purposes license in Florida. So again, you will have to wait that 30 or 90 days hard suspension if you have waited more than 10 days or if you do nothing about your administrative driver's license suspension. Option number two, you can request a formal review hearing with the Department of Highway Safety Motor Vehicles Bureau of Administrative Review. So, at this hearing, if you request the hearing inside of this 10-day window, you will be granted a business purposes hardship license that will bridge you from your date of request up until the date of the hearing, and it's for 42 days. I don't know why that's the number, but that is the number that they will issue the license for. The hearing officer is there to make two determinations and two determinations only. Number one, was there probable cause to make an arrest? And number two, did the person either provide a breath sample over the legal limit, or did they refuse to provide a breath sample or urine sample after being read implied consent instructions? That's it. They are not there to hear about your individual hardships. So if you tell them, I'm really sorry, I'm so embarrassed this happened, I've got a sick mother, I have to take my kids to school, I drive for a living, I'm going to get fired if I don't get my license back, I'm a truck driver, this is going to be, those are not things they are allowed to consider. This is not a subjective driver's license. It is objective. And again, two things and two things only are part of that formal review hearing. Was there probable cause? So again, what went into arresting the subject? How were you talking? How did you look? How did you behave? What was your driving pattern? Did you do field sobriety exercises? What are the officer's observations that went into determining that they were going to arrest and charge you with driving under the influence? Now, if you have defenses to all of that, if you can prove that it was an illegal stop or search and seizure, again, you may be able to overcome that first element of probable cause. The second element they will look at is, did you provide a breath sample over the legal limit? And then if so, the breath test operator would be required to lay out the foundation. Are they authorized to operate an intoxilizer? What was your breath result? Is it properly moved into evidence? And if it's satisfied, then that will satisfy that specific element as to providing a breath sample over the legal limit. Or if you refused, was it a willful refusal? Were you read implied consent? I've had cases where somebody might be deemed to have refused a urine specimen because they couldn't provide a sample in a very short amount of time. Well, the hearing officer determined that you can't put somebody on a specific clock. You can't control your biology when it comes to providing a urine sample. So that license suspension was actually invalidated. I just want to make clear what the formal reviewing hearing is and is not. A lot of people want to go to these hearings and they're going to, just put out their life story on why they need a break. Fortunately, a hearing officer is required by law to make a determination on only those two things: probable cause to make an arrest and whether the person provided a breath sample over the legal limit or refused. That's option 2. There is a third option, but it's only for people with a first-time DUI arrest and only if you have a non-commercial driver's license. You can, during the 10-day period from date of arrest, enroll in the DUI Level 1 school in the county in which you live or work and bring proof of that enrollment along with a copy of your citation to your nearest Bureau of Administrative Review office. You can request an informal hearing, which takes about 5 minutes, and if approved, they will suspend your license, just like they would have if you did nothing, or if you lose the hearing with option 2 for 6, 12, or 18 months, depending on what's going on. But they will issue you a hardship license for the entirety of that suspension, meaning there won't be a hard suspension period. You won't have to wait the 30 days. You won't have to wait the 90 days if you refused. You can get a hardship license for the entire period. Again, this is only for first-time DUI offenses. If you have a prior DUI conviction, or if you have a commercial driver's license, you will not be eligible to get a hardship license. Again, if you have a prior, and there is no such thing as a hardship commercial license. If you're able to get a hardship license and you have a CDL, it will be a Class E license, not a Class A or Class B commercial license, hardship business purposes license. So a business purposes license in Florida is very restrictive on what you are allowed to drive for. There is an employment purposes license, which is typically not issued, and that is you can drive to and from work or for work purposes, and that is it. If you are given a business purposes license, it lets you drive to and from and for work. It lets you drive to and from educational opportunities, and there are certain there's case law that allows for certain other places where you can drive to and from religious services. Obviously, if there's a medical emergency, you're allowed to drive to and from that. And courts have found that a person can drive to and from food, go to a grocery store, etc. But driving to the gym, picking up your kids, picking up a medication that you have a prescription for that you can get mailed, driving to the beach, going to the movies, those are forbidden. And if the police stop you and you have a business purposes or an employment purposes license and you are not driving for one of the authorized reasons, you can be arrested on a new misdemeanor charge for unlawfully driving on a restricted license. And if it's because of a DUI that your license is restricted, you are going to open up a whole new world of pain in your case. So be careful. If you have a business or employment purposes license, make sure you are following to a T what those restrictions are and when you can and can't drive. So again, your 3 options in summary of what you can do administratively are do nothing, and you know the timetables for the license suspensions and what you can do. Request a formal review hearing, or if it's a first offense and a first offense only, you can opt to waive the formal review hearing, do an informal hearing, and request a driver's license. The administrative process can be pretty complicated. Talk to a local attorney in your area. They can help walk you through or even take you through the process for you. They can even appear on your behalf without your presence if you do a formal review hearing. And a lawyer can explain all the nuances, what your possible defenses are, and your chances of success in it, and taking a formal review hearing forward.